Mr. DeMeo?
May it please the Court, Christopher DeMeo for T&D Video, and with me is Jeffrey Strom. The issue in this case is whether the trial court properly included in the attorney's fee award he made under 42 U.S.C. 1988 appellate attorney's fees, which related to the appeal of a preliminary injunction that was brought in this court back in 1995, 1996. Revere brought that appeal. They lost. Subsequently, the preliminary injunction was converted into a permanent injunction, which was the only relief that T&D had sought. So T&D obtained complete relief in this case. The ordinance in question, a zoning ordinance, was held unconstitutional. That was affirmed by the appeals court. Further review was sought in this court without success and before the U.S. Supreme Court without success. So that is now beyond review. Having obtained complete relief that it sought under 1988 and under the Supreme Court's Hensley case, T&D is entitled to, as a matter of right, to attorney's fees unless circumstances would render it unjust. Now, the appeals court held, in the course of an opinion that held generally that the attorney's fees were too high, that on remand, the trial judge, Judge Murphy, was to exclude from his calculation fees relating to the appeal back in 95, 96. And I should add, the appeals court held generally that the fees were too high, and we have not appealed that. We do not challenge that. So we understand that the case will be returned to the trial court with him taking a fresh look at this issue.
Now, Mr. DeMeo, at the time of that the appeals court led its opinion, it didn't have the benefit of the United States Supreme Court decision in Seoul, correct?
That is true.
And so until that time, a not unreasonable reading might have been that you, for 1988 purposes, and we're bound by federal law on this, that essentially attorney's fees for a preliminary injunction status quo, you don't get them, correct?
I think the Seoul case is of a piece with a long line of other cases, Supreme Court cases.
That's correct, but the Supreme Court has specifically left open, in other words, it has suggested that it's not impermissible to grant. What I'm saying is the appeals court at that time, if you simply looked at the plethora of cases of whether or not a party was entitled to attorney's fees under 1988 in connection with preliminary injunctive proceedings, a not unreasonable interpretation was you don't get that. Now the Supreme Court has clarified is if you lose, you don't get them. But when you actually win, they're leaving open that question, correct?
Well, that's correct. That's correct. But the Seoul decision also makes clear, as a matter of timing, that the only way to determine whether you in fact won at the end of the day
is to wait
after
until
the decision has been made on the merits.
Correct.
And that's consistent with the long line of
Right.
cases, the Hanaran case, the Texas teachers case that had gone back into the 80s.
So those conditions are satisfied here.
Well, they're satisfied now. They weren't satisfied.
No, I know, but at this point we can say under the Seoul decision you get what you want.
Correct.
With the
And
amount, of course, to be adjusted.
Correct. It is well settled that appellate attorney's fees are awardable under 1988. There's a lot of cases on that where the appeals court has taken the appeal sort of as the last step of the litigation after a decision on the merits in the lower court. And we have that decision now.
So there are two requirements here. You win on the preliminary injunction, which you did, and then you win on the merits.
Correct.
And you don't have to do it. You don't have to seek attorney's fees until you've got a determination on the merits,
Correct.
because you can no longer, under Seoul, as I read it, obtain attorney's fees under 1988, even if you prevail at a preliminary injunction, but you lose on the merits. Correct?
That is correct.
So
And,
that's a status quo thing. So you, in essence, have to wait until you've had a final determination.
that is exactly correct under the Seoul case.
So really, from your point of view, there's nothing to this case.
From our point of view, there's nothing to this case. The only
Except a remand back saying, recalculate the amount.
Correct.
Well, now, is there still an open question as to where you go for the appellate attorney's fees?
Oh, yeah.
Well, the wrinkle in this case is that the opinion that brought us here from the appellate court is sort of terse, and it's not entirely clear what they had in mind. But this court's decisions in Fabra, and York had talked about the appellate court being in the best position to award appellate attorney's fees.
So you go to the appeals court.
Or, well, it talks about whatever the appellate court in question was. So apparently they had in mind, since the SJC decided this in 1996, this would be the best court. The York case, the Fabra case.
Of course, the person that wrote that opinion isn't on the bench anymore, I think. Isn't that right?
I'm sorry.
Who wrote the original?
The original opinion, I believe, was Justice O'Connor.
Okay.
Right. But those cases all deal with instances where there's been a decision on the merits, you get an appeal,
Right.
and there's some kind of fee-shifting provision, a statute or a contractual provision,
Well-
and you know that at the time of the appeal, you're going to have a right to the appellate attorney's fees if you actually prevail on
Yeah.
appeal.
Who did the decision on the preliminary injunction, us or the appeals court?
It's really cool.
We did. Justice O'Connor.
Justice O'Connor did. It went
Okay,
directly.
so the answer is that we should do, if you win, we should do the calculation.
Well, that's not,
I don't object to that. We asked, the reason
But
we a-
in the federal courts, I take it, the federal practice under Section 1988 is that at least as to interlocutory appeals, which this was,
Correct.
the trial court can make that decision when it looks at the whole ball of wax.
That is how it is done, and for that reason, we requested it here, and also really to be consistent, because there doesn't seem to be a process in place now for a judge in Judge Murphy's position to send this discrete question up to this court. So it appears to me if you were a trial judge and we have a federal right to relief here, and he has to do something. So it appears to me he really acted quite reasonably in assuming he had to award these fees. And I should add, no one ever objected. Revere didn't object in the trial court or the appellate court. This is something the appeals court.
Who do you say you should calculate the fees?
We've requested that they go back to Judge Murphy, as I mentioned, simply because
He has already done all the
he's
other
already
calculations.
done all that, and there's going to be a remand, and there may be another hearing, and they may very well call Mr. Albrecht, who's the former attorney who handled this back in the 1990s, to be a witness, and he would have that advantage. And I guess the other reason is...
Are you looking for fees for what you're doing here today?
Yes.
yes,
Yes,
and that would be this court, I take it.
that would be this court.
So it's sort of going to be bifurcated.
Yes.
And it's always going to be bifurcated. I mean, if you win on appeal, the question of, I take it, well, no, that's not true. The question of,
No, it will be bifurcated.
it could be
because-
bifurcated. You could win on, you could have lost in the trial court and then win on appeal, and then end up having to go back to the trial court for attorney's fees down there, which were never set for you,
Correct.
and then have to deal with appellate attorney's fees in the appellate court.
Separately, correct. But it appears to me that in this case where you have an interlocutory appeal like this, and your right to attorney's fees is not vested at the end of the interlocutory appeal, even if you get a favorable decision, there's not really a process in place for a trial court, for someone in Judge Murphy's position here, to settle the matter other than awarding the fees himself. And that's the only reason, that's the main reason we requested that the whole issue be sent back down to him.
Thank you, Mr. DeMay.
Thank you.
Unless you, I mean, Mr. Zelaznik?
Good morning. May it please the Court, my name is Ira Zelaznik, and I represent the City of Revere and the other municipal defendants who were appellants in the court below. I would suggest to the Court that there's some confusion here between process and procedure and substance and rules of substantive law. Essentially, what the appeals court did was to apply the well-established rules of Massachusetts practice, which are that the court that takes the action is the one to assess the attorney's fees, and that's well-established in Massachusetts. And the appeals court simply said, that it should not be up to the Superior Court judge to determine the worth and the value of the services rendered to the Supreme Judicial Court. It should be that court. It shouldn't be us either.
But that's what's done in the federal system under Section 1988 cases.
Yes, but as the Draper case makes clear, the states are entitled in implementing 1988 to establish their own procedures, and this is certainly a very sound principle that the court that is dealing with the case and knows procedures and practices and how much work is involved in various matters, that court ought to be the one to assess attorney's fees, not a court that has no or lesser familiarity with the practices and procedures of that court.
But doesn't the trial court judge have a perspective that the appellate courts don't have, and that is where this application for a preliminary injunction fit into the overall entity of the litigation, because it takes on a life of its own, a trial. And a trial court judge may have a better perspective or a different slant than we have on how necessary it was to get the preliminary injunction and the value it was to preserve the rights that were involved.
I would suggest that the trial court at the trial court level certainly is better qualified to determine whether or not the initial issuance of the injunction, what the value of that was. But when it comes to determining that question on appeal, that it ought to be the appellate court that decided the interlocutory appeal that makes that determination in the absence of express authorization from the appellate court saying, I will send it back down.
So you want us to send it to the appeals court?
Well, you want that decision because you say there was a procedural misstep.
Yes.
So if it's in the appeals court, if in fact as a matter of law we conclude that you cannot have a superior court judge make this determination, and it must be by the appellate court wherever the appeal was pending, and because there was no request at the file in the brief, correct?
There was no request in the brief.
But there could be no request in the brief, at least at the time that, because it was an interlocutory order, and under Section 1988, you couldn't get it.
That's not correct, Your Honor, and I think the law was far less well established back at the time that the briefs were filed to this court.
It was far less established in terms of whether you had to ask for it in your brief, and it was far less established whether you could. I mean, we're now going to have to clarify, because we have a rule, a procedural rule that says in essence, if you ever want to get appellate fees, you have to ask for them in your brief. And we've now got, at least for purposes of 1988, and we may that you are not entitled to them at that time. So I suppose one way to say is a cautious attorney would say, I know I'm not entitled to them yet, but I'm going to ask for them. But we generally frown on people making requests which cannot be acted on.
Given the uncertainty of the law at that time, the reasonably prudent attorney would have, at the interlocutory appeal stage.
The question is whether a reasonably prudent attorney might have asked, but the law wasn't absolutely clear at that time that you had to ask, was it?
The law at that time, I think the applicable decision was York,
and it
which said that
should.
You should.
And
so
we clarified in Farbrae that should means must. But
Correct.
There was uncertainty as to whether it did.
Correct.
Some people
But
asked.
I would suggest to the court that it's not unreasonable to ask counsel who, after all, are seeking attorney's fees at the rate of $400 an hour to cover their bases during that time.
How much counsel charge is irrelevant. The question is whether we, say as a matter of law, if you didn't do something which was not settled by law at the time, that you are now precluded from recovering.
I would suggest that it's more, Your Honor, a question of the court's discretion, whether the court chooses to exercise discretion so as to permit the request for attorney's fees to be acted on either by this court or by the lower court in the event that you so decide. And I would suggest that it is a discretionary call as opposed to an interpretive one as a matter of law.
You don't have any question that, on a general basis, they're entitled to fees under this latest decision because the merits were decided and so forth.
That's
It's just,
correct,
we're
Your
just haggling over the best way to do it and whether they should have requested and all that kind of stuff.
Well, the appeals court held, and we would suggest rightfully so, that the failure to have started the machinery to request those fees at an earlier stage of the litigation amounts to a waiver of the request for those fees.
But that's why we're here. That may be
Correct.
wrong.
Correct. I'd like to just take 1 minute, if I may, Your Honor, on another procedural.
There's one question. Your brief here, Mr. Zalesnik, was filed in March of 2007, and the Supreme Court's decision was June of 2007. And in essence, the Supreme Court leaves open the question. It doesn't address the question. It says you can't get them if you don't prevail. You can't get preliminary injunctive fees if you don't prevail. But it leaves open the question of whether you can get them. Do you have a view as to whether they must be given? They must be awarded? That's what I understood the import of your...
If the party ultimately prevails, I think the law is settled that you're entitled to ask for them, and like all other fee questions under Section 1988, those fees should be granted unless there are special circumstances that would warrant the denial of those fees. And I don't think that the Supreme Court's most recent decision in that regard really changed the law. I think they simply restated or expressly stated what had been plainly foreshadowed in their prior opinions. What was slightly different in that case was that, in essence, the preliminary injunction afforded the party the complete relief. Their relief was they wanted the art exhibition shown or the exhibition on the beach conducted, and it was conducted, so that really the preliminary injunction in that case was like what frequently occurs. The preliminary injunction is effectively the end of the case. But I really don't think that decision advanced the state of the law much beyond where Buchanan really was before, and that was a somewhat aberrant appeals court decision. I'd just like to take 1 minute on the procedural issue that brings us here, because I think it would be helpful to the bar to have some clarification of that point. This petition for further appellate review was filed roughly 3 months after the date of the rescript. And under Rule 27.1, the petition is to be filed in this court within 20 days. It may, under federal practice, it's the rule that a filing of a petition for rehearing stays the necessity for filing a petition for certiorari. It may well be what this court wants the rule to be. It's been, I think, the common understanding of the bar that the filing of a petition for rehearing with the appeals court does not stay the time. And I would just ask that the court clarify that for the members of the bar. I remember many years ago when Mr. Justice Greene was on the appeals court, he inserted a very helpful footnote in, I think it was case Lyons versus Labor Relations Commissions, telling us not to cite unreported decisions, summary dispositions of the appeals court. If the court could do something to that effect, I think it would be helpful to the bar. Just clarifying, is it 20 days, or do you need to file a motion to extend the time? Do you need to file a motion after the fact for leave to file late, none of which was done here? Or is it simply that the filing of a petition for rehearing stays the tolls the time for filing a petition until...
Did you file a motion to strike the petition for further appellate review as untimely?
I filed in my brief the argument that it should be dismissed because it's untimely, and I opposed...
In your brief in opposition to the petition?
In opposition, I filed it as well. I think it's a subsidiary issue to the issue raised by the petitioner, and I think I'd certainly like the court to address it. The principal question is whether in the exercise of your discretion that the decision of the appeals court ought to be reversed and fees awarded for the appellate work on the interlocutory appeal that took place earlier in the case. And I would suggest that in the exercise of this court's discretion, the better course is simply to let matters stand. It's going back for a remand to the Superior Court for the assessment of attorney's fees for the principal work in the case on the trial level. The appeals court has before it a petition for attorney's fees for the appeal to the appeals court, and this court obviously now has a request before it for attorney's fees for this appeal. With respect to the interlocutory appeal, I would suggest the exercise of discretion properly calls for the fees not to be awarded. Had counsel covered the bases, it could have, in the earlier interlocutory appeal, not only asked for the authority for the Superior Court judge to assess fees if they ultimately prevailed after trial. That would have covered the uncertainty as to whether or not they were entitled to fees at that point. They could have pointed out that there was ample authority in the First Circuit at that time that would support the request for fees at that time. So a request for fees could have been framed in the alternative. At that time, the bases would have been covered and all the alternatives met. They did not do so. They waited until the very end, even though it was not clear at that time under the state of the law that they had to do so. There's no real hardship to the appellee, to T&D, on this. There's a claim made that they're a small business. In fact, the records show that the business paid very, very little towards the attorney's fees, and that counsel was relying pretty much from the outset on the attorney's fees award as what their fees would be, and that there's not any question that there's going to be a balanced billing or a billing of the excess between what they charge on their bills versus what the court awards. There's no harm to Section 1988 because there's going to be an award under Section 1988. They are going to be compensated for over 90% of the work that they did. By their own acknowledgement, the interlocutory appeal constituted less than 10% of their entire work. And indeed, we're back in this predicament largely because
Remind me, you took the interlocutory appeal?
I took the interlocutory appeal, Your Honor.
So the town took the interlocutory
Yes.
appeal?
That's correct, Your Honor. And I don't mean to suggest that had not the procedural steps been taken, they wouldn't have been entitled to fees. They would have been under 1988. But the procedural missteps, I would suggest to the court, warrant a denial of fees in this case. And we're only back before this court, and we're only continuing this litigation because the fee request was excessive, grossly excessive in the first place, and the appeals court so found. So in light of all those circumstances, I would request that this court affirm the decision of the appeals court and permit the case to be remanded back to the Superior Court for assessment of fees and deny fees for this appeal. Thank you very much.
Thank you, Mr. Zeleznik.